Madame Cronus. Bonjour tout le monde.
Good morning, everyone, and welcome to meeting 25 of the Justice and Human Rights Committee meeting.
Conference of February 2nd, 2026, the committee is meeting to resume its study of Bill C-16, an act to amend certain acts in relation to criminal and correctional matters. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I would like to confirm that sound tests were made successfully. Is that correct? Okay. Before we continue, I would ask all in-person participants to consult the guidelines written on the cards on the table. These measures are in place to help prevent audio and feedback incidents and to protect the health and safety of all participants, including the interpreters. You will also notice a QR code on the card which links to a short awareness video. I would like to make a few comments for the benefits of witnesses and members. Number one, please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. For those on Zoom, at the bottom of your screen, you can select the appropriate channel for interpretation, either the floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can, and we appreciate your patience and understanding in this regard. Bienvenue à nous.
Welcome to our witnesses on the program today, appearing today for our first hour. We have with us as an individual.
Fair, Assistant Professor from the University of Saskatchewan, Ms. Joanne Blinko from the Alberta Elder Abuse Awareness Council, and Dr. Benjamin Robach appearing in person from the Federal Ombudsman for Victims of Crime. The floor is yours for your opening remarks, up to 5 minutes, followed by questions from the members. Mr. Fair.
Thank you for the invitation to comment on this important bill. I'll focus on Section 63, which proposes a safety valve clause for most minimum sentences of imprisonment. And in support of this legislation, I'll make 4 comments. First, this legislation is the minimum constitutional response to the problems posed by mandatory sentences. As the Supreme Court states in Lloyd, for a minimum sentence to survive charter scrutiny, there is only one requirement, that the residual discretion allow for a lesser sentence where the mandatory minimum results in cruel and unusual punishment. That is precisely what Bill 16 proposes. It is also well known that the phrase cruel and unusual in law means grossly disproportionate. Application of this standard ensures that Parliament maintains substantial influence over sentencing. The ubiquity of the gross disproportionality standard in charter jurisprudence also ensures that courts have access to a rich body of cases to guide them in crafting exemptions. And this leads me to my second comment. Despite current jurisprudence, some judges will likely err for problematic reasons, including reasons that perpetuate sexual myths and stereotypes. I and others accordingly have recommended that certain factors be excluded from consideration when applying the exemption clause for, say, the sex offender registry, and a similar recommendation seems apt here. Specifically excluded reasons might include the following non-exhaustive list taken from Section 51 of South Africa's Criminal Law Amendments Act. These include the complainant's previous sexual history, an apparent lack of physical injury to the complainant, an accused's cultural or religious beliefs about sexual assault, and any relationship between the accused and complainant. Parliament may also consider excluding self-induced intoxication as a relevant factor as occurs under the Australian Northern Territories legislation. My third comment is that Parliament should further contemplate how courts will use their exemption power in hard cases. Bill C-16 still requires imposition of some prison sentence in cases where the exemption applies, presumably because Section 742.1 subsection B of the Criminal Code will thereby prevent judges from imposing a conditional sentence order. Judges will likely respond by sentencing some offenders to a one-day sentence and a probation order, which likely will be upheld on appeal in some cases. If Parliament thinks this would be imprudent, it should permit limited access to conditional sentence orders. In some cases, such a sentence may better achieve denunciation and deterrence. Finally, a caution is warranted with respect to the minimum sentences that are excluded from the safety valve. While the minimum sentences for first and second degree murder were upheld in Luxton and Latimer, these cases applied a now overruled methodology for constitutionally assessing minimum sentences. A more expansive approach to foreseeable scenarios, combined with much improved evidence on the impact of long-term imprisonment on prisoners, as well as the repeal of the faint hope clause, suggests rechallenges have a reasonable prospect of success, although I acknowledge that reasonable people may disagree on this point. Even if those challenges fail, though, the minimum sentences for murder are problematic for another reason. They create a strong incentive to plead guilty to a lesser included offense like manslaughter, despite the accused possessing a potentially meritorious defense. This problem is particularly prone to arise for battered women who kill their abusers and plead self-defense. It may also arise when an accused presents strong evidence of a breach of charter rights during police investigation, but exclusion of evidence is uncertain. Parliament may address this problem by either extending the exemption to all homicides or, more narrowly, allowing judges to circumvent a minimum sentence if the incentive to forfeit a defense unduly risks a wrongful conviction. And while these suggestions require detailed consideration, I want to close by re-emphasizing that the current legislation is a prudent response to Quebec Attorney General V. Senneville in this political moment. It also provides an excellent template to build upon after Parliament gathers evidence with respect to how the safety valve is applied. Thank you.
Thank you, sir. Moving on to Ms. Blincoe, you have 5 minutes.
Thank you for the opportunity to speak today. My name is Joanne Blincoe, and I work with the Alberta Elder Abuse Awareness Council. Our work focuses on strengthening a community response to elder abuse across the province of Alberta through coordination, education, and support for frontline service providers and communities. Every day, we see the impact of elder abuse on older adults and their families. Elder abuse can take many forms, including financial exploitation, emotional abuse, sexual abuse, neglect, and physical harm. One of the most difficult and least visible dynamics we encounter within these forms of abuse is coercive control. Coercive control often underlies many situations of elder abuse. It involves patterns of manipulation, intimidation, isolation, and control that limits the older adult's independence and ability to make their own decisions. This can include restricting their access to money, isolating them from family and friends, monitoring their communication, or pressuring them to sign legal documents such as powers of attorney. Unlike a single incident of abuse, coercive control often develops slowly over time. Because of this, it can be extremely difficult for older adults, families, and even professionals to recognize what is happening. We also know that the older women are disproportionately affected. Rates of abuse among older women are higher than in older men, particularly in situations involving family relationships, dependency, and coercive control. For many women, this may reflect patterns of control that have existed for years and continue into later life. In Alberta, we are in a unique position compared to other parts of Canada. Across the province, we have specialized elder abuse case managers and coordinated community response teams that work together to support the older adult who is at risk of abuse or currently experiencing abuse. These teams bring together community organizations, social services, law enforcement, and other professionals to respond to complex situations and support the safety and autonomy of older adults. Because of this coordinated system, we are also able to see patterns that might otherwise remain hidden. In our casework, we are seeing situations where coercive control is a significant factor in elder abuse, particularly in older women seeking support. This tells us that coercive control is not just a theoretical issue. It is something that is actively affecting older adults in our communities today. Recognizing coercive control within policy and legal frameworks would help communities, professionals, and systems respond earlier and more effectively to protect older adults. Thank you again for the opportunity to contribute to this important discussion. Thank you.
Thank you. And then moving on to Dr. Roebuck, you have up to 5 minutes.
Thank you, Chair. We're meeting today on the unceded, unsurrendered territory of the Algonquin Anishinaabe people. As we mark Red Dress Day on May 5th, I want to acknowledge the families of missing and murdered Indigenous women and girls and Two-Spirit people and other survivors calling for justice. Bill C-16 represents the most significant advancement in federal victims' rights since the Canadian Victims' Bill of Rights in 2015. It responds to half of the recommendations from our national systemic investigation, Rethinking Justice for Survivors of Sexual Violence, which included consultations with thousands of survivors, frontline workers, service providers, justice professionals, and experts across Canada. The bill includes recognition of victim interests in delay in Jordan applications, presumptive access to testimonial aids, a criminal code framework for restorative justice, expanded protections for sexual offenses and sexual exploitation, an expansion of the Canadian Victims' Bill of Rights, including a new right to respect and fairness. The CVBR is quasi-constitutional legislation. Parliament gave it primacy and linked victims' rights to the Charter and the proper administration of justice. At the same time, the CVBR imposes extraordinary limitations on enforcement. Section 27 denies legal status on the rights, Section 28 denies civil remedies, and Section 29 denies appeals based on violations of the CVBR. Victim rights in other countries are not so constrained. Sections 27 to 29 should be repealed. If they remain, procedural fairness requires that the complaints mechanism chosen by Parliament be clear, accessible, and effective. C-16 expands the scope of admissible CVBR complaints. One improvement Parliament can make is to name the Office of the Federal Ombudsperson for Victims of Crime in the CVBR complaints and remedies provisions, including Section 25, Sub 2. This is not mandate expansion, it's procedural clarity. Other quasi-constitutional statutes have named oversight bodies to support independent review and consistent application. Under the CVBR, we still have practical gaps, including limits on access to information required to assess complaints, particularly under the Corrections and Conditional Release Act. If victims are directed to a complaints-based system as their primary form of redress, that system must be capable of meaningful review. Proposed Section 8.1 to the CVBR on federal entities with information sharing obligations is a positive development, but the list must be explicitly non-exhaustive. The provision should state including but not limited to, and it should explicitly name Canada Border Services Agency and the Department of Justice. Survivors should have a right to know when the person who harmed them has been removed from Canada as a result of a criminal offense, regardless of whether a sentence has expired. This is a narrow, safety-focused clarification to address CVBR complaints. In one case, a survivor spent years in witness protection and has no right to know if the person who harmed her has been removed from Canada. And I strongly support reforms to better protect therapeutic records. These reforms respond directly to our investigation and the advocacy of survivors. We heard that subpoenas for counseling records forced survivors into impossible choices between asking for mental health care or participating in the justice process. In our national survey, 20% of survivors of sexual violence avoided counseling due to the fear their records could be subpoenaed. 13% chose not to report to police for the same reason. One survivor told us, "When I heard he was applying for my counseling records, I wanted to die." Beyond the human cost, these practices drive delay and inefficiency. Records applications are brought mid-trial, triggering adjournments, Jordan risks, prolonged proceedings, and increased costs across the justice system. By raising the admissibility threshold to innocence at stake, Bill C-16 protects survivors' access to life-saving care, reduces speculative and last-minute applications, minimizes delay, and strengthens public confidence in the justice system. This reform safeguards full answer and defense by allowing access to records when they're necessary, while eliminating practices that have a discriminatory impact on women's access to health care. Thank you.
Roebuck. We're now moving on to members' questions. Mr. Gill, floor is yours. You have 6 minutes.
Thank you, Mr. Chair, and good morning, everyone. I would like to thank all the witnesses for their testimony and their contribution to our committee's study on this bill. Dr. Roebuck, my questions will be for you today. Firstly, I wanted to thank you for your service to protecting and advancing the rights of victims of crimes in Canada. Your 10th year progress reports on the Victims' Bill of Rights stated that the Liberal government ignored all 15 recommendations you made to improve the bill in 2020. Does this bill include any of those recommendations?
It does. The bill includes extensively recommendations that our office has made, both to improve the Canadian Victims' Bill of Rights and in other areas of substantive fairness for survivors.
And have you raised the issues that Victims' Bill of Rights is not enforceable to the minister?
We've raised that issue consistently across every platform imaginable.
What did they tell you?
This is something for all of Parliament. It's not a one-party issue. I think in this committee, you can decide together how you want to address the enforceability of those rights.
Given the bill you oversee is amended by Bill C-16, I assume that you had input on the drafting process as well?
We function as a special advisor to the minister and provide input regularly. We don't have access to cabinet confidence, so we can't see the technical provisions before they're introduced to the public, but we do provide answers to questions.
Did you recommend more changes to the Bill of Rights beyond those that appear in Bill C-16?
Sorry, I missed the beginning.
Did you recommend more changes to the Bill of Rights beyond those that appear in Bill C-16?
Yes, in both progress reports, the 5-year and the 10-year, there's recommendations beyond what's included in the bill.
Did the government ever explain why they ignore your other amendments, and how will victims be affected by the half measures they have taken?
We still need stronger enforcement on the victim rights, and we need courts particularly to recognize the quasi-constitutional nature of the CVBR. One of our biggest challenges is that even though this is meant to guide the interpretation of the criminal code, it's still not included in provincial licensing exams to practice law, where it's an error in law not to consider some of these rights and decisions. So it needs to be picked up.
Okay. How many femicides are there per year?
That's a great question.
C'est une excellente question. Je ne connais pas les chiffres. Quel est le pourcentage de ces dossiers qui touchent les systèmes de santé mentale ou autres? Les cas de féminicide. Oui, bien sûr, les gens connaissent ce qui se passe. Dans quel... Il est courant, oui, que les gens soient au courant. On nous dit que c'est à hauteur de 83%. Vous avez dit aux sénateurs que les fournisseurs de services ont déjà téléphoné, ont déjà parlé au téléphone sans préavis pour les libérations conditionnelles. Qu'en est-il de cette question des libérations conditionnelles? Oui, on a voulu renforcer les dispositions quant aux libérations conditionnelles, mais on n'a toujours pas informé les victimes lorsque quelqu'un pose un risque létal si cette personne est libérée. Entre 2018 et 2025, combien de femmes ont été tuées dans le cadre d'une ordonnance de protection par des personnes libérées par libération conditionnelle? Plus de 52. Combien avaient une historique de violence? Bon nombre de ces personnes avaient déjà reçu des peines et je pense que 57% étaient liés à de la violence à l'égard de partenaires intimes. J'aimerais m'adresser maintenant à Madame Blinco. La semaine dernière, quelqu'un... Non, désolé. Je n'ai pas le bon document.
That's up. She's there. Oh, okay. Okay. So we have heard a lot about.
On a entendu parler du contrôle coercitif dans les relations entre partenaires intimes. À quoi cela peut-il ressembler dans d'autres contextes? En Alberta, nous avons 25 gestionnaires de dossiers qui offrent un appui aux adultes. Habituellement, le tout était axé sur la violence faite aux femmes, mais c'est beaucoup plus prévalent, ce contrôle coercitif, dans la maltraitance des aidés. Et c'est beaucoup plus subtil que dans la violence axée sur le genre. Pour les femmes plus âgées, par exemple, elles ne peuvent pas se divorcer de leur enfant. Et donc, ce que l'on constate, c'est qu'il y a de la manipulation. Par exemple, vous ne pourrez plus voir vos petits-enfants ou de l'intimidation. On leur dit que si elles continuent ainsi, elles se retrouveront dans un foyer. Et donc, la maltraitance chez les aînés et le contrôle coercitif, selon moi, est encore beaucoup plus courant que par la violence axée sur le genre.
You now have 6 minutes, Madame Latanzio. Thank you, Chair.
Will be addressed to
J'aimerais m'adresser à M. Fair. Dans la décision de la Cour suprême du Canada, vous a cité dans votre travail sur des scénarios hypothétiques raisonnables, à savoir quand il y aurait disproportion de la peine. Donc, j'aimerais m'adresser à vous pour les questions observations. Le C16 rétablit certaines peines minimales obligatoires qui, précédemment, avaient été éliminées par les tribunaux parce que dans certains cas, cela pourrait se traduire par des peines disproportionnées. Vous avez dit que la meilleure approche est d'adopter, je vous cite, une disposition, une soupape de sécurité qui imposerait une peine moins importante ou une peine minimale obligatoire se traduirait par une punition trop sévère au terme de la Constitution. Donc, selon vous, est-ce qu'on trouve l'équilibre exact en préservant l'intention du Parlement tout en se fiant aux tribunaux qui doivent examiner tous les scénarios, même la constitutionnalité de la peine? Merci pour cette question. Oui, je pense que il y a dans le projet de loi un équilibre. Il y a un genre de lutte constitutionnelle entre le Parlement et les tribunaux, à savoir qu'est-ce qui est une peine proportionnée. Quand on parle de proportionnalité dans les peines, il faut équilibrer toutes sortes de principes généraux, comment dissuader, comment réadapter, et ainsi de suite. Donc, pour trouver la punition juste, équitable, c'est un exercice difficile. Donc, pour les tribunaux et les juristes, et c'est ce qu'on voit dans ces cas de peine minimale, les tribunaux se servent du scénario le plus susceptible d'arriver et le C16 indique que ce qu'il faudra faire, c'est d'éliminer ce scénario raisonnablement prévisible de la part des tribunaux. Et donc, les peines minimales obligatoires seraient exemptées uniquement si la disposition de soupape de sécurité s'appliquait. Dans bon nombre de champs de compétences dans le monde, on utilise des soupapes de sécurité selon diverses normes. On pourrait dire, par exemple, que si on s'éloigne trop d'une peine habituelle, il faudrait établir une exemption. Mais au Canada, il faut, pour accorder une exemption, que la peine soit exagérément disproportionnée. Selon vous, l'inclusion?
Chair, I don't want to interrupt our colleague, but I'd just like to mention an anomaly. The translation in French is coming out on the English channel. I've found it, but is everyone finding it? I wonder whether if there's a problem.
I was on French for a while and I was getting
OK. Ouais, on me fait signe que ça irait. OK. Merci, Monsieur le Président.
Mr. Chair, I take it that the time was interrupted,
Oui.
and I have, okay, thank you. Thank you. Mr. Fair, let me put this quote to you. People, and I quote, "People will say that mandatory minimums failed in the Harper era. They failed because of all we needed was a safety valve to say," and again, quote, "except in exceptional circumstances." That's it. These remarks were made in 2025, just recently, by a Conservative member of Parliament and current public safety critic in support of adding the safety valve to mandatory minimum penalties. Yet today, the Conservatives are opposing Bill C-16, which includes this very mechanism. Could you comment on why this issue should not be partisan and why it is important to move forward with criminal justice reforms that are both effective and constitutionally sound?
Well, I do think that this is the most common proposal to the problem of minimum sentences, and I agree with those comments made earlier by the Conservatives and then by the Liberals here in proposing the exemption found in Section 63. But I think that the exemption standard in Section 63 is probably more prudent because it speaks directly to the standard used in constitutional law in Canada. Using language such as exceptional circumstances, that's a different term. And in fact, we've seen that used in many states in Australia and other jurisdictions. And it would create a lot of confusion out of the gate to use a standard like exceptional circumstances. Using the language proposed is quite clear to courts. There's a rich body of jurisprudence, even though, again, it can be quite difficult to apply this gross disproportionality exemption, but at least there's a rich body of jurisprudence. So I think that the proposed standard is quite prudent.
Next question is to you, Dr. Roebuck. The bill would require the courts to consider remedies other than the stay of proceedings for breaches of Section 11B following the Jordan case, and you spoke about it very briefly in your opening remarks. Do you believe that this strikes the right balance between protecting the rights of victims and of the accused and ensuring victims are not denied justice due to delays? And are there risks or improvement you would highlight?
Thank you. It's part of the picture. In our systemic investigation, we published a specific chapter looking at how Jordan is operating across the justice system, and providing notice to victims is a really critical piece that's included in the bill. But we've seen in 2022, 2023, sexual assaults were the most likely criminal offense to be stayed under RV Jordan. And it was just the tip of the iceberg because many cases were withdrawn preemptively when they weren't likely to be resolved before passing the threshold. So considering alternatives to stays is critical, and some of the other measures that are included in the bill are responsive to our recommendations.
Vous avez 6 minutes.
You have 6 minutes, Mr. Fortin. Thank you, Chair. Mr. Fair, first of all, welcome to all the witnesses. I've got a question for you. On the question of femicides, I'd like to know whether you're proposing a definition. Is there one that you think would be most appropriate to define a femicide? You're on mute, sir.
What I've proposed is to consider a complementary exemption standard if Parliament's not willing to extend the exemption to homicides. I'm proposing that Parliament consider a circumstance where a battered woman is faced with a claim that they committed a homicide and did not do so in self-defense. This can create all kinds of difficult choices for that accused person, because they have to roll the dice as to whether or not they will succeed on their claim of self-defense.
Professeur Fair, ma question s'adressait.
Professor Fair, I was talking about the definition or the problem of defining femicide. For example, there's 3 possible scenarios. For example, a lady who is so-called accidentally killed in an armed bank robbery because she's there at the wrong time, or someone who's killed by someone because they want their life insurance, which is a considerable amount, so it's an economic-based murder, and another woman who's killed by a jealous spouse who thinks that she's been cheating and kills her out of hatred and violence, fueled by sentiments. Or, for example, a woman who's killed. For example, when we saw what happened at the University of Montreal, where someone killed several women at Polytechnique just because they're women. He didn't know them personally. He didn't have specific hatred against one particular individual, but he killed them simply because they were women. So in these 4 situations, it seems to me that there's important distinctions to be made. And when we refer to the term femicide, should we apply it to all of the examples I've listed, or do we need to circumscribe femicide to cover some of these examples, but not all?
Okay, I didn't make any comments on femicide per se. I am here to speak about the exemptions to
Non, je sais que vous n'avez pas fait. Je me demandais si vous aviez une opinion.
I know you didn't comment on it, but I wanted to see if you had an opinion on that. I'll leave it there because I don't want to lose your time. Thank you very much, Professor Fair. Mr. Roebuck, do you have an opinion on this, namely the definition of a femicide? Should we apply it to all murders of women or circumscribe it to specific situations?
Contexts of gender-based oppression that frame many of the homicides are broad, and women and girls are more likely to be murdered for reasons that intersect with that gender identity than men are to be murdered in different circumstances. I think right now the definition that's being provided in the law is limited only to intimate partners, when we know that there are other gender-based motivated reasons that could be captured.
Mais quand vous dites intimate partner, là.
But when you refer to intimate partner, if I'm a couple with a woman who's got a 1 million life insurance policy and I've got financial problems, she's my intimate partner, I kill her. Of course, I wouldn't do that. I'm just giving an example. It's hypothetical, and I kill her to get my hands on her life insurance policy. Should we call this a femicide or a murder that's been committed, and it could have been against a man? It would have been the same thing. Are there distinctions to draw?
Department has to consider how it's being defined carefully. There's not actually a definition in the code. There's criteria for when it would be an offense, because there's a heading on femicide, but there's not a definition of femicide explicitly in the
Merci, Professeur Roebuck. Je vais vous poser une autre question sur le.
Thank you, Professor Roebuck. I've got another question. This for trans people, for example, a man who has transitioned, has become a woman, a trans woman. In this case, if he meets the other criteria, should he or she be considered as a femicide? Or if he was born a man, does that mean he should be excluded from this definition of femicide?
You'd need to clarify with the department is that it's focused in on homicide that has a hate or bias motive, and that could be gender, it could be a trans identity, and so I think that certainly it should be captured into how those provisions work.
Merci. Et sur la question des...
Thank you. On the question of reasonable delays, under C16, certain measures being put forward to counter the perverse effects of these delays that the Supreme Court has described as unreasonable delays under the Charter. So do you think C16 is proposing a good way forward to deal with this? Or should we look at something else?
It's a good approach. Oh,
Please.
yeah, I believe it's a good approach, and many of the provisions respond to recommendations from our report.
Merci, Monsieur Fortin. That completes our first round. Moving to
Thank you, Mr. Fulton.
starting off with Ms. Cronus. You have 5 minutes.
Mr. Chair, and Ms. Blinco, I want to thank you for coming to here to talk about this very important issue of coercive control as it relates to seniors. As you've sort of alluded to in your opening statement, of course, coercive control with seniors is sometimes harder to recognize because independence is something that vanishes slowly under the manipulation or pressure or emotional influence in sometimes a subtle way that often even feels like help. And so it's a particularly a difficult form of elder abuse to recognize. And I was wondering whether or not you might elaborate on some of the more common ways that coercive control shows up in the lives of seniors, especially when it comes to financial scams or exploitations or other criminal measures.
Thank you for your question. I think when we're dealing with older adults, what does come forward is the son who, in our statistics, between the ages of 45 and 49, is the most prevalent in terms of person who is causing harm, is what we're seeing in those circumstances are they come forward to help. They come forward under the umbrella of providing support. And what ends up happening is they end up controlling their money. And often by banks, police officers cannot lay charge, even when we're getting involved as case managers. When you're seeing those elements, it's really hard to read because you have someone who's trying to step forward to help, but it doesn't come that way when the older adult describes that. That comes through in their health, that comes through in the fear that they have. Those are elements that are at play. Does that answer your question then?
It does, and thank you so much for taking the time to explain it. I'm wondering if you could also talk about whether or not there are warning signs that family members, friends, and neighbors often miss until it's too late.
There is. What happens is there is a decline in their health. There are things that they typically had happen. For example, they have no hearing aids. Their glasses are not replaced. They look disheveled. They're not attending community activities anymore. They're not participating in the same way. Their personalities, we're seeing differences where they might have been outgoing. Now they're becoming much more reserved. There are signs that come forward, but often are overlooked. The difference as well with an older adult is that their circle of isolation is tighter. So when you're looking at child abuse, they attend school, other people have eyes on them, but when you're dealing with situations of elder abuse and they're not going to their church anymore, they're not going to the senior center anymore, those are really hard to identify.
And it sounds like the telltale sign in this particular case is that there is an adult who is supposedly there to help them, and yet they are still showing signs of not being helped.
Correct. That's what we see in the work. So when we're looking at circumstances where people are at risk, we see that social isolation. They're saying they're stepping forward to help, and that's not the circumstance. Often what we see is mental health issues for the person causing harm. We see a sense of entitlement. We see addiction issues. We see family history of abuse along the way, and we see financial concerns for that person who has caused harm as well.
Perspective, is there a way that legislation could better support prevention and not just respond to the harms in the way that Bill 16 is doing?
So currently what happens if an older adult has been abused by a son, a daughter, a family member, often it doesn't fit under the criminal code. Whereas if we could see this ahead with a definition of coercive control, that would allow us as service providers across the province to be able to step in and report those incidents, to talk about what is happening, and that would give that prevention piece that we don't have existing now.
And just briefly, in the time that we have left, could you expand a little bit on the gaps that education and community outreach could help fill when it comes to coercive control as a particularly pernicious and dangerous form of elder abuse?
So, very quickly.
Okay, so what we're finding is that coercive control is really, like you said, hard to spot. So if we provided education training across the province, across the country, then we'd be able to find those prevention ways to get in. Right now, we don't have that avenue.
Thank you. Thank you, Ms. Coronis. Ms. Dillon, you have 5 minutes.
Thank you, Mr. Chair, and thank you to our witnesses for being here today. I'd like to ask questions to Mrs. Blinco because for me, protecting elders is something I really, really take to heart. I would like to start with asking you, how would you define coercive control against an elderly person?
When we look at the elements of abuse, we're looking at physical abuse. The elements that we see when our caseworkers support older adults and community. Coercive control is the underlying elements that facilitate that manipulation, that intimidation, those things that are occurring. For example, hey, Mom, I'll run to the bank and I'll get you out money that you need for the groceries. Meanwhile, what's happening is they take the card and they go buy a new suit. They run to the bank and they take out $100. Those are the pieces that we're seeing where coercive control. One of the biggest one that comes forward is when older adults don't have access to their grandchildren. And so if they're saying you don't sign this power of attorney, you won't see your grandchildren anymore. That's how we see coercive control coming through.
And according to you, I guess it's easier for these caretaking adult children to say that they have dementia or they're not feeling well. How often do you see that?
That is often what we see. I'm really just here to help Mom. You know, she must have misconstrued. And even when they take Mom to the doctor, a daughter takes Mom to the doctor, you know, no, Mom, it's okay. I'll manage this situation. So coercive control fits in with the majority of caseworkers defining an element of elder abuse. And so when you have physical or emotional abuse that is occurring, those underlying issues are coming from their way to maintain how that coercive control exists, how that element of abuse continues between their family member and the older adult.
And have you seen an increase in elder abuse and coercive control over the years? Has it increasingly got worse or it's stable?
I would say it's continuing to worsen. So when I look at some of the economic factors for people in their own lives, where there is elements of a sense of entitlement, those are pieces that are becoming much more prevalent. It's probably one of our second areas of a sense of entitlement where that's happening. We also have issues around addictions and mental health, which again is also increasing. So those numbers of coercive control are becoming much more obvious, even though they're hard to spot in terms of where they fit.
And do you ever have interventions at seniors' homes, long-term home cares? Where
Yes.
there's, yeah, okay.
Okay, yes. So here in Alberta, I guess we're in that unique position where we have case managers across the province in rural, remote, and Indigenous communities. If I look across the country, we're able to identify we had 900 cases in 1 year, and some of those have occurred in seniors' homes. In lodges. So we're allowed to be able to go in, to be able to identify what are the factors at play, what are the elements of abuse, and how can we support the older adult. Bottom line is we let the older adult determine where we're going to go. I think that's a key factor in terms of supporting them to address the issue of abuse that is happening to them.
And most often in these homes, it comes out in the news with nanny cams, hidden devices that a family member figures out they are being subjected to abuse. Sometimes we see vicious beatings. A few weeks ago, the horrific news of an elderly person being sexually assaulted. How do you deal with these situations?
So what we're finding is the education that we're presenting across the province is making a difference by educating the public and talking about powers of attorney, what is elder abuse, by bringing attention and light to that, and that it exists in the manipulation, the intimidation of older adults. That's what seems to be making the difference. So the numbers are increasing where older adults themselves are coming forward to say, this is not right and this is not the way I choose to live.
And
that's your time. Monsieur Fortin, vous avez 2 minutes et demie.
You have 2.5 minutes, Mr. Fortin.
Monsieur le Président.
Thank you, Chair. Mr. Roebuck. C16 proposes a change of 264.1 on harassment in order to adopt a more objective approach to this, namely whether the victim truly fears for their safety or whether a reasonable person in these circumstances would fear for their safety. I'd like to hear from you that. Do you think C16 is putting forward the right approach on this, or should we change it?
We don't need courts to be weighing in to myths and stereotypes on how people respond to harassment, and I think that an objective standard is a safer one that doesn't put a trauma burden on survivors to justify why they're afraid.
Je prends l'article 1 du projet de loi.
If we take 27.1 of C16, it takes 274.1 and it changes the wording. Do you think that's appropriate?
J'imagine vous avez lu.
I imagine you've read C16 and we've got section 27 that puts forward new wording for 274.1. Do you think that this new wording is correct?
When we look at the provision, we think that it's well mapped out, so the wording is strong.
Dans les circonstances,
So in these circumstances, do you think that 810.3 of the Criminal Code, which deals with a similar situation where we're talking about recognizance to keep the peace, should we not keep 810.3 and then see if it can be harmonized with the new wording for 274.1?
It's a good suggestion. I think that there should be alignment.
OK, merci. Je pense que mon temps, 2 minutes.
Thank you. I think my time is up.
20 secondes.
20 seconds left. Well, thank you very much, Mr. Roebuck, Mr. Fair, and Ms. Brinko. Thank you.
Merci. Moving on to Mr. Lawton, 5 minutes.
Thank you, Mr. Chair. You're doing a bang-up job, if I do say so myself. One of my Liberal colleagues had erroneously mentioned earlier that Conservatives are opposing Bill C-16, which is not the case. Conservatives did not oppose Bill C-16 at second reading, and I can speak personally. I've had very favourable things to say about much of the bill and certainly the objectives of the bill. I think the points of contention have been around making sure that it lives up to what it's supposed to do, in particular the sections to do with mandatory minimum penalties. So, Dr. Fair, I'd like to begin with you on this, because you were actually cited by both the majority and the dissent in Senneville, which I think speaks to the fact that you are quite respected in your work, and there's something in it for anyone. But you indicated in your testimony today that C-16, as it relates to minimums, is the minimum that we could do. I was hoping you could elaborate on that.
Sure. Thank you for your question. It's an excellent question. What C-16 does is it applies to minimum sentences of imprisonment minus those where life imprisonment is the minimum. So I say minimum, that this is the minimal response because there are cases that I had mentioned that upheld some of those life sentences, the homicide cases in particular, Lux and Latimer. And when you survey the jurisprudence on other types of minimum penalties, and I'm thinking here about things like mandatory minimum fines. We see some of those in the criminal code. In a book that I have coming out on Section 12 of the Charter, it seems quite evident to me when I weave that jurisprudence together that those punishments are being upheld by the courts. They're not cruel and unusual. The main contention turns on minimum sentences of imprisonment. And here, when Bill C-16 says that an exemption may apply when the minimum sentence would apply to the offender before the court in a way that is cruel and unusual, meaning grossly disproportionate, then they may be exempted from that standard. So in many other jurisdictions, if we go to South Africa, some states in the United States, in England, certainly in Australia, they use a variety of standards, and some of these standards may be prudent in some circumstances, but
thank you.
As Canada,
I have to be mindful of my time here, but I do appreciate that, Dr. Fair. Let me just ask you, if I may, about the safety valve approach, because one thing we saw in the original trial judge decisions in Senneville and Nod was already a disregard for the mandatory minimums in place because of this finding of cruel and unusual punishment, which didn't even have to do with the reasonable hypotheticals that were brought in later. So what is to stop judges that are inherently lenient from taking advantage of this safety valve to just circumvent mandatory minimums that Parliament has put in place?
Another excellent question. I think whenever you apply any sort of standard-based rule, there's going to be some ironing out. And what we will see, I suspect, is appellate courts doing precisely what they did in Senneville, where the Quebec Court of Appeal and the Supreme Court of Canada overwhelmingly said, no, sentencing judge, you are wrong as to whether the punishment is unconstitutional for Mr. Senneville. So there will be some ironing out. That's pretty new with pretty common with any new law, but I have some faith that appellate courts will show the requisite amount of deference.
I tend to be a fan of McIntyre's dissent in Smith from 1987 in basically saying that reasonable hypotheticals shouldn't be brought in. The decisions should be made with the case at hand. I feel like that horse has left the barn in the last 40 years or so. But let me ask you about the reasonable hypothetical in this case, because one of the challenges is that it's supposing that a charge would have even been laid in that, the most tolerable scenario imaginable under that. And do you think that needs to be taken into account? And could there be a way to give judges direction on limiting these hypotheticals?
Again, an excellent question. I proposed such a way, and 4 of 9 judges agreed with me on trying to build in some middle ground, as the Chief Justice and Justice Cote called it. I think the adversarial process has taken its course, and that idea was rejected by a majority of the court, and as a result, the next most reasonable thing to do is precisely what Bill C-16 is proposing, which is to enact a safety valve, allow the courts to deal with this on a case-by-case basis, because now we don't need to think about the reasonably foreseeable scenario, except for in the context of life imprisonment, where these exemptions don't apply.
Father, 5 minutes.
Thank you very much, Mr. Chair, and I will echo Mr. Lawton. I think you're doing an excellent job today. I also thought Mr. Lawton's questions were very good. I don't necessarily agree with McIntyre's 1987 dissent, but I'm sympathetic, and certainly in the light of Seneville. And by the way, Mr. Farrer, I do have to congratulate you on being cited both by the majority and by the minority in Seneville, because that is a rare feat. Even if you would have preferred that the minority's hypothesis would have won the day. Thank you also to both of the other witnesses. I'm going to start with Ms. Blincoe, please. Ms. Blincoe, obviously, I think myself and probably many others are very sympathetic to the idea of what you're proposing, which is that coercive control at some point also be extended to other vulnerable groups, particularly seniors. And certainly the what you said was very true. I'm seeing it happen more and more often as well in our communities. One of the things that is happening with this bill, though, is that we have included a 2-year coming into force period to prepare the system. And we need to fully assess the data, fully assess the impact, fully assess how it's functioning. Given that in the initial discussions about the bill, it was very much focused on one type of coercive control, which was in the relationship-based, would you support a system where, for example, the government, although maybe we not included in this bill, we include a review period, and then the government undertake consultations with respect to seniors, so we would get the input of a wide variety of stakeholders onto how to best deal with this issue with respect to coercive control over seniors, using perhaps the wrong words, but...
Thank you. I think if it's possible to get it right from the get-go, being able to look at gender-based violence, intimate partner violence, and relatives, that will give us a better headway to be able to make a difference in elder abuse. If we continue to wait, those situations of elder abuse, and some of them are horrific, they're going to continue to occur, and there isn't a way to be able to resolve that. So preference would be that we do that right away before we have more situations that are occurring. Just my opinion.
Is very valid, and I'm not trying to in any way negate the importance of this issue. I just think that, as I've, in my, 10 years here in Parliament, walked how laws are crafted, usually there's, significant consultation that goes into crafting, certainly if it's a government bill and even private members' bills. And I think what happened here, rightly or wrongly, is the coercive control aspect focused on intimate partner relationships and one type of relationship, and didn't really consider this extended, very true situation. So I'm sympathetic also to those who say we need to consult perhaps and set up a proper framework for it. But again, your points were really, I think, well made. And just so that you just one last question: do you believe that the framework that is used here can just instantly apply, or should it be adapted? Like looking at the provisions in the bill related to coercive control, for example.
I would hope that they could get instantly adapted. So when I look at the elements of play and people who are dealing with situations of gender-based violence, that older women are in that criteria. They are in that way to be able to support where gender-based violence exists. When I look at my stats, 55% are with a family member, 24% are in intimate partner violence. So it still exists. So if there's a way to be able, and we don't have specific stats, but what we look at is all of the elements that have been in play. So when we look at our coalition that has come together, there is information out there that does identify those things of older women.
Thank you. Mr. Chair, do I have any time left?
30 seconds.
30 seconds. Dr. Roebuck, I just wanted to say one thing. One of my colleagues kept talking about how some of your recommendations were ignored. I think you clarified that a number of the things you proposed were in the bill, and the fact that some others weren't doesn't mean they were actually ignored. I just wanted to ask, the Bill 16 proposes to expand victims' access to information and awareness and protection measures, as you had mentioned. Does the ability reduce the burden on the victim to opt in? Is this a better framework than we had before?
It's a great improvement. There's still areas that need to be improved in time, but it's much better.
Thank you so much.
Okay, thank you. Dr. Fair, I have one question, actually a couple of questions. What is the name of your upcoming book, and when will it be released?
Actually, two books that are generally on point that are being released this summer, one in June and one in July. The first is called Rethinking Homicide, the Constitutional Case for Reform. The second is called Cruel and Unusual, Section 12 of the Canadian Charter of Rights and Freedoms.
Okay, thank you. All right.
Thank you.
We're going to suspend for a few minutes while we get ready for the second panel. Meeting is back on. Pour la 12e heure, nous avons...
For the second hour, We have with us Ms. Nancy Boucher, registered practical nurse, Mr. Rizwan Khan
from the National Institute on Aging, and from the Valora Place, Liz Brown. You each have 5 minutes to provide your opening statement. That'll be followed by questions from the members. Madame Boucher. You may continue.
It's me?
Oui.
Merci.
Thank you very much. So I'm Nancy Boucher, and I'm here today not just as a citizen, but as a survivor. A woman who intimately knows in her flesh and in her memory what intimate partner violence destroys. It doesn't just leave bruises, it strips us, it rips away our dignity, suffocates our confidence, and shatters peace. And too often it kills. I am the voice for those who are absent and those we can still save. We are meeting here within the context of Bill C-16, but for me, this is not just one text amongst others. Rather, it's a break line, a rupture between what we've tolerated for too long and what we now refuse to accept. A clear line that says, this far and no further. The reconsideration of minimum sentences is an essential step because that's where it all starts. That's where the system speaks. That's where it sends a message about what is unacceptable and what unfortunately still seems to be tolerated. When the sentence no longer reflects the seriousness of the act nor the repetition thereof, then the message becomes dangerous and indicative of a system that is abdicating its protective role. And without a firm response, recidivism gains a foothold, it takes root, and it becomes foreseeable. But we must also ask ourselves an essential question. If leniency and sweet, feeble sentences have been the response for years, what have been the results? And this then begs the question, why in so many cases does impunity still seem to be the norm? A clear, firm, and real sentence can break a trajectory. It can lead to awareness. It can break a cycle before it destroys another life. Intimate partner violence is not an abstract concept. It's children who are afraid, broken families, and sometimes coffins that appear too soon. What we choose today is whether these children will have a future or just a memory. When there is no remorse, no change, there can be no complacency. The system's response must be firm, constant, and without hesitation. The Criminal Code already provides mechanisms for dangerous and long-term offenders. These mechanisms must be fully used, especially with reoffenders in the case of IPV, because at this stage it's no longer an accident, it's a pattern choice, and a repeated choice demands that responsibility be taken. Every day we delay is a day too late. In the meantime, women hesitate, they keep silent for fear of not being believed nor protected. And silence turns into danger. They're asked to be perfect, to remember everything, to be irreproachable, to remain coherent despite the trauma, to speak precisely despite the fact that they've had to survive in fear, as if their trauma didn't exist, as if survival were simply linear. But one question must be asked. Is the legal system itself beyond reproach? I am here to put an end to silence being the answer. Domestic violence is not an isolated event. Rather, it's a process. It gains grip, then control over someone. Fear that slowly sets up home until it becomes an invisible prison. Femicide isn't a point of departure, it's a point of arrival. the final stage in an escalation of violence. It must be recognized and treated with the utmost seriousness, namely as first-degree murder, because femicide isn't an inevitable crime. It's a crime we can prevent, fight, and reduce to the point of elimination. It's not a private tragedy. It's an avoidable collective failure. We know the mechanisms, we know the signs. Bill C-16 is an opportunity to clearly state that intimate partner violence in all its forms has no place in our society anymore. It should never again be minimized, never again excused, never again tolerated.
Depending on the question presented to you, but that is your 5 minutes. Mr. Khan, you have upwards to 5 minutes for your opening statement.
Thank you, Mr. Chair and members of the committee for this opportunity to testify before you. I am a lawyer and at the National Institute on Aging, the NIA, a research and policy institute housed at the Toronto Metropolitan University. For the past 10 years, we have worked to build a Canada where older adults feel valued, included, supported, and better prepared to age with confidence. We appreciate the government's effort under Bill C-16 to criminalize coercive control. Coercive control captures a pattern of gradual but escalating abuse that may involve intimidation, isolation, financial exploitation, and interference with a person's autonomy. It is precisely this kind of abuse that too often goes unrecognized when the law only focuses on discrete incidents rather than cumulative patterns of harm. Recognizing coercive control is especially important in addressing violence against women, as it is a known precursor to intimate partner homicide. Our central message today is simple. The proposed coercive control provisions under Bill C-16 are too narrow, leaving many older adults, particularly older women, behind. This risks creating a two-tiered system of justice. The coercive control offense under Bill C-16 is currently limited to intimate partner relationships. That may capture an important part of violence against women, but it does not capture the full reality of abuse experienced by older women. Many older women are not being coercively controlled by a spouse or partner. They are being controlled by sons, other relatives, and in some cases, informal caregivers. Yet if the same pattern of abuse is carried out by a son rather than a spouse, the proposed offense would not apply. This means that justice would depend on how a relationship is labeled rather than the nature of the harm itself. This gap matters because if Bill C-16 is meant to respond to gender-based patterns of coercive control, then it should not exclude a whole segment of women simply because the abuse occurs in the context of another family relationship. Data also makes this gap harder to ignore. As our submission noted, Statistics Canada shows that 36% of older adult victims of family violence were victimized by their child, while 28% were victimized by a spouse. When siblings and extended family are included, non-intimate partner abuse accounts for the majority of cases involving older adults. So the question is this: should a proposed offense designed to protect women from a pattern of escalating abuse exclude older women who are subjected to a comparable abuse by family members other than intimate partners? In our respectful submission, the answer is no. The caregiving context is also important. Most caregivers provide compassionate and appropriate support, but not every caregiving relationship is free from harm. Where one person depends on another for daily living, there is an obvious power imbalance. In some cases, that imbalance can be exploited in ways that are functionally indistinguishable from coercive control by an intimate partner. That is why leaving caregivers outside the scope of the offense creates an additional and significant gap. International experience also supports a broader approach. As noted in our submission, England and Wales recognize coercive control where parties are personally connected, and Queensland in Australia expressly extends protection to include wider family members as well as informal caregivers. Other jurisdictions such as New South Wales and Ireland started with a narrower model for coercive control, are now reconsidering their approach. So rather than adopting an under-inclusive framework now and revisiting the issue later, Canada can get this right from the outset. Amending Bill C-16 to include relatives and informal caregivers would not weaken the offense. It would ensure the offense is faithful to the legislative intent behind its creation, and ensure older women are not carved out of a response aimed at protecting women from a pattern of sustained control and abuse. For that reason, the NIA recommends that Bill C-16 be amended so that the coercive control offense applies not only to current or former intimate partners, but also to relatives and informal caregivers. Without this amendment, many older women facing serious abuse through coercive control will remain outside the law's protection simply because the label attached to the viewing relationship. Thank you once again for considering my testimony.
Mr. Khan, Ms. Brown, you have upwards to 5 minutes.
Thank you. Good morning, and thank you for the invitation to join you today. Thank you also for your work. It's deeply heartening that the federal government has focused on gender-based violence. There's evident care and clearly a lot of positive intent behind the almost 2 pounds worth of paper that has come from the Bill C-16. There's a lot of heart that has brought it to this stage and has put the issue of gender-based violence front and center. That is really important. 6 years ago today, the reverberating horror of mass casualty was felt across Canada. In 13 hours from April 18th to April 19th, one man in 2020 continued his long-standing pattern of coercive control with a physical assault against his intimate partner, then proceeded to end the lives of 22 people. A mass casualty commission was created. Its final report is both powerful and sobering. It has a clarion call to action that includes recommendations that are highly relevant to consider in review of the proposed changes included in Bill C-16. We know that gender-based violence occurs in the context of relationships. It is with someone that we know and love, and sometimes loved in the past tense. It is intentional. It's not a single act. It's rather a pattern of behaviors and actions that are designed to reduce our sense of safety, well-being, and self-efficacy. It increases fear, it increases vigilance, and it is the heart of abuse. It includes social isolation from family, friends, and colleagues, financial abuse, psychological abuse, monitoring, not giving us our basic human rights when we go to the bathroom, when we sleep, when we are able to contact our friends. It threatens our animals, our pets, the people that have meaning to us, along with threats to harm self or to end their own lives by suicide. It does include criminal harassment, it does include physical assault, and it does include sexual assault. It upends our sense of self. It is so insidious that we can begin to question our very own sanity and live in a constant state of vigilance and fear. It isolates and erodes our autonomy. And coercive control is largely invisible at first glance. We can't see it on a person. It's a pattern of actions that are knitted together in such a tight web that is often outside of both public and community view. It's done by usual people, folks we couldn't profile or consider reasonably likely to cause harm. It is widespread in homes across postal codes, rural routes, town streets, and city intersections. Bill C-16 is presented to address these concerns. It is both well-intended, and there are some significant concerns to consider also in what will happen when we criminalize coercive control. Criminalization has significantly greater and disproportionate effects on marginalized communities, including Indigenous people, racialized people, and people living in fiscal poverty. This impact is gendered. It's experienced with greater severity and frequency by Indigenous women, racialized women, trans women, disabled women, and women living in fiscal poverty. The unintended consequence of Bill 16 will also increase the likelihood of women who've experienced harm being criminalized too. This happened when back in the 80s we implemented mandatory charging, and more women were charged with forms of harm and control against their partner. More women were also criminalized. In our country, we have more Indigenous women in federal incarceration. Over 50% are Indigenous women, way more than the 5% of Indigenous women on Turtle Island. We encourage the federal government to implement recommendation V8 of the Mass Casualty Commission to look at the development of a common framework for understanding women-centric risk assessments that really understand the unique challenges that people who identify as women face. We recommend there be no changes to the criminal harassment legislation currently, and no removal of subjective fear requirement and a change to the objective fear requirement. We do support inclusion of increased support for survivors and witnesses in proceedings, the increased emphasis on and meaning of the appropriate use of restorative justice processes to heal, and the expansion of intimate image definition to include deep fakes. We do assert that police, crowns, and judges require new and specific mandatory training to address what constitutes coercive control. We'd recommend a public education campaign before implementation and throughout to encourage understanding of this pattern of intimate partner violence. It's really, really important to heed the call from the Mass Casualty Commission to pay attention to the epidemic of violence against women and intimate partner harm, with epidemic-level funding for gender-based violence prevention and intervention.
That's your time. You may have an opportunity of completing your opening statement with a question. Starting our first round, Mr. Lawton, you have 6 minutes.
Thank you, Mr. Chair. Thank you, witnesses, and thank you in particular, Ms. Brown. You do, as well as Valora Place, tremendous work back home in our riding, so I'm glad you were able to be here today. One aspect that we haven't yet heard any testimony on is one that I know you know all too well, given that Valora Place serves women in St. Thomas and Elgin, and that is the unique character of rural communities as it relates to intimate partner violence. And I was wondering if you could speak to how that deserves very specific consideration in the context of our broader discussion on intimate partner violence.
Coercive control in any setting is very challenging. In rural communities where I work and live, I have lack of cell phone reception at multiple times throughout my day. There is profound isolation. There is not public transportation. There is not a neighbor who hears your calls for help. There is not a person who observes that you haven't left the house. There isn't another person who sees that your partner has harmed your livestock, your animals that make the constitution, the foundation of your farm and your community life. It is very difficult to be seen in rural communities, very difficult to have access to services, timely access, and to be heard, to be able to be supported and helped. It's a real issue.
I mean, rural cellular coverage goes far beyond what we're able to do in this bill and on this committee. But when you point that out, I think it speaks to the fact that in some of these relationships, someone may only have a very narrow window of time or opportunity to seek help. You know, what are better ways that we could do through legislation or even through other things we're working on as a parliament to try to account for that problem, to try to better reach women in these communities that might have an extra challenge, an extra hurdle in getting help?
I again go back to the Mass Casualty Commission and also what we've known in our own hearts of women who've experienced harm and harm we've experienced ourselves, that public education happens in community. So it happens by being able to gather together. It happens by being able to talk about what has happened in our lives and be able to discuss the reality of harm in confidential and private ways. To be able to do that, you have to know who you can call. You have to be able to access that location or multiple locations. And you have to know that what happened to you isn't because you're crazy. You may feel crazy as a result of the harm, but you're not. And you need to be believed from the point of the very first person who hears you.
One challenge I know you've spoken up about in the past, and I know you worked a great deal with my predecessor, Karen Vecchio, who did phenomenal work as an MP on this, including at the Status of Women Committee. And that is the harmonization or the need for better harmonization between levels of government. You know, the law federally is what we can deal with here, but beyond that, I know you've identified as a service provider challenges in the way that you have to, where we are, deal with federal, municipal, county, provincial, and a lot of the times not all of these levels are rowing in the same direction.
Yes, and I don't anticipate rowing in the same direction, to be honest. I anticipate there'd be difference of opinion, that there'd be challenges, and that there'll also be possibility in seeing it differently at a municipal level, provincial level, and national level. I think the national level sets the tone. If femicide is included in the legislation, which I will admit I couldn't find the actual word, and I did look for it a lot. If it's included in the legislation, it names the reality of the gender-based fact of harm against women. This sends an important message to our municipal and our provincial partners about how fundamentally essential it is to recognize and to be really clear about its importance to address. I think there's lots of opportunity across politics and across political parties because everyone holds a heart and a desire to show up to make this corner of the world better. And so I really believe there's an opportunity for nonpartisan participation. We exist as a result of work by NDP NDP, Liberal, and Conservative governments that have made it possible to support thousands of women each and every single year. I think it creates more possibility than challenge.
You've touched on what has become a frequent discussion point in our committee deliberations, which is how we view femicide.
Yes.
Femicide isn't defined in the legislation. It is mentioned in a heading of a section. But when we look at what we're actually describing it as, it includes a hate-motivated offense against women or people with other identifiable characteristics. It also includes an intimate partner scenario in which it could theoretically be a woman victim. So what would you like to see as the way, if you were amending the bill, as how we navigate or how we engage with that term, femicide?
Yeah, for sure. I think clarity is important. I think to have the definition right in the bill is important. It is women being killed as a result of being women. So to be really clear about what that means, it can be quite distilled. There's been a number of presentations to the committee by a number of legal groups, the National Association of Lawyers and the Legal Action Fund as well, who've been very clear about the wording that can be used to encapsulate that. When it's that clear, it names the gendered reality of harm. It makes it abundantly clear for both federal, provincial, and municipal governments.
Now, in that context, I mean, someone could be victimized by intimate partner violence regardless of whether they're a woman or a man. We know that women are disproportionately the victims here. Do you think that that distinction is necessary?
Yes, because femicide is different than murder generally, in that there are more women being murdered in intimate relationships than there are people who identify as male. That's statistically founded in what the federal government has shared through Stats Canada repeatedly. And it is so different, the risk and fear for being murdered because one is a woman.
Thank you.
Thank you, Mr. Lawson. Madame Latanzio, vous avez 6 minutes.
6 minutes. You have 6 minutes. Thank you, Chair.
For being present today and for participating in this very important study of Bill C-16. Merci à vous, Madame Boucher, d'avoir pris.
Thank you very much, Ms. Bushy, for having come here in person to share your proposals on this new bill. I'd like to say that I agree with you when you've said that silence is no longer the answer, nor is it the solution. So thank you very much for that. So for my question will be for you. There's already been 10 femicides in Quebec. Just in the first 4 months between January and April, we've already 10 femicides in Quebec, and Bill C-16 is proposing that there would be an explicit reference to femicide in the criminal code. Are you in favour of this? And can you explain to us what would be the impact of including this in the criminal code to ensure that survivors and victims' families clearly know once and for all that femicide has been integrated into the criminal code? I think it's absolutely primordial that really needs to be included in the code, because for too long, men that have come before the courts in terms of domestic violence, it's been minimised, and the system has shown that people have been playing with the system for too long, and unfortunately, these men are extremely manipulative. They know how the system works. So now we have to really show very clearly that this Bill C-16 shows that we're entering a new era where women can feel that they're in safety, they feel protected, believed and supported. And it will show men that femicide is no longer acceptable. There are now going to be consequences in line with the acts that they've committed. That really is essential. Because, as you've said, there's already been 10 femicides this year in Quebec. And we've almost gone beyond the figures for the whole of 2025 already. So clearly there's something that's not working in terms of the justice system. Intimate partner violence and femicides are too present in our society today. So it's time to stand up and show that this is no longer acceptable. We're not going to allow these men to be in this revolving door system with the criminal justice system. We have to show there's consequences for their acts, because when you're a multiple reoffender, in terms of femicides, it's a question of escalation. And as I said earlier, domestic violence doesn't start with a murder, it starts with coercive control. And it's very important for this to be included in Bill C-16. That means the police officers will be able to intervene and prevent these femicides, and this escalation of intimate partner violence will clearly show that this is no longer acceptable. Thank you very much.
Brown, you spoke about it very briefly in your opening remarks in terms of the deep fakes. So we are increasingly seeing technology used to create sexually explicit deep fakes without consent. Would you agree that updating the law to capture these forms of abuse is necessary to keep pace with how perpetrators are today targeting women?
Yes.
Yes, okay.
My shortest answer of the day.
Okay. The bill also criminalizes threats to distribute intimate images, including deep fakes, and increases penalties. In your experience, how commonly are these kinds of threats used as tools of coercion and control in abusive relationships, and how important is it to address them explicitly in the criminal code?
Used often, yes. Used often and known to police, no. So most of the harm, in fact, I was thinking about this morning, of all the women we walk beside every single year, less than 5% ever speak to a police officer about the harm they've experienced, ever speak about a deep fake image that has arisen. Their view and faith in the justice system is at low levels as a result of many, many reasons, not the least of which is concern they won't be believed, shame they feel for what has happened to them, and a real resistance to having their decisions interrogated and questioned. And this has caused, I think, low reporting in many different crimes that have occurred, including the distribution of deep fakes, as well as the distribution of nude pictures and pictures of sexual acts that haven't been consented for distribution.
And so what measures can be taken to have more women come forward?
Yeah. New and accountable training for policing, crowns, and judges. It's really important that we know how to respond when someone comes and tells us the harm they've experienced. I may come with a smile on my face. I may come speaking as if I'm talking about a grocery list, and I'm talking about the most profound violation of my mind, body, and spirit. We have to be ready to accept that the congruence may not be there. We have to see patterns, not single incidences of harm. We have to be curious and say, okay, so he hit you. What happened the day before? What happened the week before? What happened the month before? Have you ever felt unsafe with him? Have you ever wondered about him sharing information about you? Has he ever shared photographs you weren't comfortable with? We have to see it as a pattern, not as a single act, and be able to realize that it is so pervasive, and it is not profiled, and it is not obvious, and it is insidious. So we have to train, and we have to be prepared.
Thank you, Ms. Brown. Monsieur Fortin, vous avez 6 minutes.
Mr. Fortin, you have 6 minutes. Thank you, Chair. Thank you very much, Ms. Boucher, Ms. Brown, and also Maître Khan. Ms. Bougie, we've already had some conversations on what happened to you. And once again, I would like to reiterate my full sympathy and the sadness that we feel when we hear what happened to you. I'll try and remain objective and effective here. And based on your testimony, it's the same thing for Ms. Brown. You said we need to be believed. You've said it's important for a woman who's complaining to actually be believed. Could you further develop that? Madam Brown has just talked about this. Often this is interpreted as something that's contradictory to the presumption of innocence. A woman complains about domestic violence. The police officer reacts as Ms. Brown said, because she explained to us how this happens. But can you talk about this, the importance of being believed, and that it's a useful process so that when a woman complains, there's actual follow-up. They need to be taken seriously, not just believed, but we need to take the complaint seriously and investigate this properly as we do with any other type of complaint. So I'd like you to talk about that aspect of your testimony. Thank you. It's not easy when we go to lodge a complaint, because with domestic violence, there's lots of prejudices that we come up against when we go to lodge a complaint. It depends on the police officer that we meet. That really will have an impact on our statement. The way they look at us, the way that the person approaches us means that we'll be more at ease, or perhaps we'll close up because we feel we're being judged again. In terms of the process with the Crown and so on, when we're a victim, we are considered as a witness, and they do as they wish with all of this. Unfortunately, I've come up against this several times. We don't feel supported, we don't feel heard, because when we ask too many questions, they say they're not a council just for us, they're a council for society in general. So that means that a woman doesn't want to complain when we know the way in which we will perhaps be perceived and the way that they'll interpret our comments, because we know that, unfortunately, women go back to a violent situation. There's a lot of judgment around this, and it's very difficult to complain because they group together lots of different charges rather than dealing with them separately. No matter how many times this happened, there were several assaults, but they just look at one assault, but we were beaten 3 times. Why is it not consecutive? So there's lots of whys around the system, and we don't really get answers. And when we see of this, for women, it means that we don't feel that we should complain because we don't feel protected to do that. And often it's more dangerous to speak out about this because we're opening ourselves up to further danger. A woman who complains a first time, it can take weeks or months or years before you find the courage to speak up. And when you're aware of the justice system and the situation today, it doesn't really encourage you to complain. So unfortunately, there's many women who don't actually speak out and complain because they feel that they're going to be further exposed to more danger. And they feel that the system's not protecting them. We're talking a great deal about C16, but there is a big issue at the heart of this in terms of the judges and prosecutors and so on. And they really need training, if you don't mind me saying that, because we're telling women to come forward and complain, but they're putting their life on the line in danger by complaining. Thank you. I don't have much time, but I'm turning to you, Ms. Brown. Would you like to add something to what Madame Boucher has just mentioned on the same matter?
Your testimony is incredibly powerful. Your experience is the experience we've had over and over and over and over again. We need to have representation in the justice system for each of us as women. So a lawyer dedicated to the woman's experience in the justice system, a similar system like we have for family court support workers in Ontario, criminal court support workers across the country who will walk with women through this experience. Just 6 years ago, after the Mass Casualty Commission, one of the first people charged was the woman who survived his violence for decades. Years, not decades. She was charged. She was blamed. This is not an aberration. This is a consistent process of blaming each of us when we've experienced harm. And the criminal justice system will continue to be inadequate, unresponsive, and unaccountable to women until we address our own attitudes, beliefs, and assumptions, and willingness to open our heart to see the truth of what actually happens on the ugly side of who we are. We can be really harmful. We can be really awful. We can be very coercive, very controlling, and we have to honor that that lives right here in this room. It lives in this country. It lives across every single postal code. So until we're honest about that, when each woman comes into the room to share their experience, they will be doubted. They will be questioned, and they will experience a moment of concern for their safety.
Thank you very much. Ms. Coronas, 5 minutes.
Thank you very much.
Merci, Madame Boucher.
Thank you, Ms. Bushy, for having shared your story with us today.
Of academics and lawyers here, and it is incredibly helpful and generous of you to share your personal experiences of intimate partner violence with us. And I'm hoping that I'll be able to ask you questions that will help continue to draw out some of the points that you're hoping to make. I want to thank my colleague for reminding us that we are studying this bill in the context of 10 femicides so far in Quebec this year, just in 2026. And in your opening remarks, you very powerfully talked about the idea that domestic violence isn't just an event, it's a process. And I was hoping that you could talk about the role of manipulation by the perpetrator, of the emotions of people involved during that process.
Oui.
Yes, thank you. Unfortunately, these men are big manipulators, as I said earlier. And then there's a judgment from society. I'm a strong woman, and nevertheless, I was taken in. Domestic violence touches all classes and all ages of women, and these men know how to draw us in, because at the beginning, we really, with the love bumping, I think, we really fall in love very quickly. We get attached to them very quickly. And they're not crazy, of course. They know what they're doing. Women know that it's not a normal experience. It's not normal for us to stay or to accept these things. And we do try. I did try tens of times to leave. But they always come and draw us back in again. They've got two complete extreme points or sides. They can be very, very nice or very, very nasty. So when we experience this type of domestic violence, it's a battle between our head and our heart every day, because if they've got our heart, they can control us, because we're thinking about the man that we knew, the one that we fell in love with. We want to see them again, but of course we've had blows and pain and suffering, and so they bring us back in with nice dinners, gifts, with rose petals floating in the bath. They know how to make us feel like a princess certain days, and they.
Does that manipulation extend into the criminal justice system? What I want to get at is the idea that does it extend into the criminal justice system? Do the partners come into the process, and do they try and manipulate the courts? Do they try and tell stories around why their sentences should be reduced, why they're really the victim in this scenario, why we should not be so hard on them?
With my ex-spouse, something was quite clear. I never removed my complaints. I complained 13 times. I never removed them. So there wasn't so much manipulation in terms of trying to withdraw any charges. He knew when he was hitting me, he would have to shoulder his responsibilities. I never withdrew this. I withdrew 8 tens, but not. There was no withdrawal of my official complaints. So it wasn't that type of manipulation of the criminal justice system, but there was lots of other forms of manipulation from which I suffered. They manipulate us. They take away all of our values. They talk about taking away our children. But in terms of the criminal justice system, that's not what I experienced because I stuck to my guns, so to speak, and my complaints and was prepared to testify in front of him.
That you did that. Do you think that there should be mandatory minimums for the things that lead up to murder that are still intimate violence, intimate partner violence within the criminal justice system?
Excusez-moi, le micro.
Sorry, do you think that there should be mandatory minimum sentences for the steps? You talked about the fact that we build up to murder. That murder is not a single event; it's a destination. It is the cumulative impact of this. And I was wondering whether or not you believe that there should be mandatory minimum sentences for that.
Very quickly, Ms. Boucher.
Oui, en fait, oui, ça devrait.
Yes, that should be the case. We know that men need to have firmer sentences from the outset, because that will show whether it's acceptable or not what they're doing. There's certain men that will avoid then escalation so that there can be some reparation. But the moment there's too many soft sentences, the probation and fines is not going to frighten men. My ex-spouse, it was 18 years before he got any sentence whatsoever.
You have 5 minutes.
Thank you so much, Mr. Chair. I will direct my questions at Mr. Khan. So thank you so much for coming and testifying today and showing your appreciation for this bill. I ran out of time in the last panel. I wanted to ask, have you been seeing also that elderly men are being subjected to abuse and coercive control?
So at the National Institute on Aging, we tend to look at data from other sources, such as some of the other witnesses here, when it comes to actual prevalence of issues. But based on the data that we have found, the prevalence of coercive control is, in fact, directed towards women. It starts off with intimate partners when they're younger, and as they get older, it shifts because the dynamics and the dependency of older individuals shifts away from spouses and more onto their children and other loved ones because of the dependence and trust and the need for them to help with their caregiving. Okay. So, based on what you've asked me, the answer is actually probably no, but it isn't. That doesn't mean that it is not occurring.
And you've mentioned, as well as other panelists, again in the previous panel, that it's sons who are committing most of these abuses and not daughters. Is it more prevalent through sons? Because it's been repeated a few times.
So, based on the data that we have found, it's a bit difficult to just say that it is coercive control only. There are different elements of crimes that sons are committing. Some of them are due to mental illness, and the dynamics with older adults is because of the love they have for their children. The child being the perpetrator makes it even more difficult for them to come forward and report. So, while it could in fact be coercive control, it is not always coercive control. When it comes to family violence, there seems to be an equal amount of abuse coming from extended families and children. When it comes to homicide, the sons are more prevalent. But when it comes to general abuse, it is the extended family that is prevalent. In fact, the last data I saw was, I think it was almost equivalent, 35 and 35% daughters and sons when it came to abuse, and not just homicide.
And usually you're saying this abuse is the result, if it's females as well doing it, daughters, through mental illness or substance abuse.
No, I was saying coercive control isn't always due. Abuse isn't always due to coercive control. Mm-hmm. When it comes to the extreme form, it is not always coercive control, because coercive control tends to want to keep the victim, for want of a better word, alive, because they're essentially, the reason why they're doing this is to extract economic benefits. Is a common element. I wanted to touch on just on why that may be the case, because as you're getting older, you may have more assets. The children and your relatives are looking to those as a means or a reason for why they are coercively controlling you. So the reasons change over time. And so, to say that violence is only being perpetrated by one gender when it comes to your children isn't quite accurate. The kinds of violence, yes, absolutely.
Okay, thank you for clarifying, because I kept hearing son. So just thank you for touching on this subject. We haven't considered in such detail and in such a manner elderly abuse, and especially now that it would be part of the criminal code. In your opinion, how can we best ensure that any potential extension of the coercive control offense to seniors is evidence-based, carefully designed, and informed by the data and experience that we gather once the current framework has been implemented?
Of course. So the best way to do it is obviously, community involvement, stakeholders, service providers, international jurisdictions, their experiences as well, taking in as much data and information as possible before taking a step forward. Based on our analysis, we've noted that other jurisdictions have already undertaken this sort of consideration and have found that when they started out at a narrower approach, specifically intimate partners alone, they found that the prevalence of violence for older adults, because it was no longer just intimate partners, it is extending out to other family members and caregivers, that it was more appropriate to extend the definition of coercive control to include not just intimate partners. So this was found essentially in England and Wales. Ireland is now currently making recommendations to make that change. Queensland started off at that stage. So our recommendation is...
Mr. Khan, thank you very much. Monsieur Fortin, vous avez 2 minutes et demie.
2.5 minutes, Mr. Fortin. Thank you, Chair. And thank you once again to the witnesses. I'd like to come back to you, Ms. Bushy, quickly. I've heard you give important testimony. I'd like to make sure that we're all on the same page. So what happened with the person who assaulted you? Did it finish after their sentence, or what happened? My ex-spouse is charged for murder currently, accused of having murdered Gabi Renault, who was a friend. She'd become a friend because she'd contacted me to ask for help and support about this. We were friends, and I helped her secretly without judging. I was aware of this phenomenon, and I was aware of this violence. Unfortunately, one day I woke up and heard that she'd been murdered. A suggestive question, not to upset you, even if I know your case well. I want to make sure that my parliamentary colleagues are with this. Gabi Renault, if I remember correctly, she was the new spouse of the individual who had assaulted you. Is that correct? Yes, is the answer. And he killed her. He's accused of having murdered her. Thank you very much, Ms. Bushy, for that clarification. Now, Ms. Brown, you said they would like us to look at the wording of 264 of the Criminal Code, which uses a subjective rather than an objective criterion. In the new wording put forward by C16, the fact that a woman fears for her safety would be sufficient, whereas in the current wording we have to prove that it's an objective fear that any reasonable person would have feared for their safety. So do you consider that we need to maintain this current criterion and not take account of the subjectivity of the situation?
No, and thank you for clarifying that with me. No, I think we need to take into account the subjectivity of the situation.
Merci, Madame Brown. C'est ce que je me...
Thank you very much. That's what I thought. I wasn't sure if I'd correctly grasped that, so thank you.
Merci, Monsieur le Président. Merci à tous les témoins.
Thank you, Chair, and thank you for all the witnesses today.
Thank you, Mr. Chair, and thanks to all witnesses for coming here for improving the bill. And my question to Ms. Brown. Peel Police have declared domestic violence in my riding of Brampton West and the city an epidemic. They respond to 46 domestic violence calls per day. Are we at a point where the federal government should call the domestic violence an epidemic? Yes. Thank you. The Renfrew inquest called on the government of Canada to explicitly recognize femicides. Do you think the Liberals got that right in this bill, or there is room to improve?
I think there's always room to improve in every single bill. And in my presentation this morning, as pointed out by your colleague, I think being serious about femicide has been so eloquently described to you this morning from my colleague to my left. Nancy has made it really clear the cost. The cost is women's lives. The current legislation in the amendment talks about controlling or coercive. It doesn't say coercive control. It is different. Coercive control is intentional, repeated, and it is what abuse is focused on. This needs to be in the legislation. So does the wording of femicide and the definition of it. And that's not because the Liberals aren't doing something about it, or not because the Conservatives aren't doing something about it, or not because the NDP aren't doing something about it. It's because there's over 200 pages of words. So some will need to be revisited, and that would be one of them I would really recommend.
Thank you. The Renfrew inquest similarly called for Parliament to make coercive control a stand-alone offense. What concerns do you have about that criminalizing victims, and what should be done about that?
Thank you so much for asking that. I'm very afraid of that. I know from experience of the last number of years, it's been over 40 now, that mandatory charging has been in effect, that women have been arrested numerous times. Dual charges have happened numerous times. This will happen with coercive control, and it will happen more often to my Indigenous sisters. It will happen more often to people who don't look like me. It will happen to racialized communities. Our criminal justice system and the federal government has said it is a justice system that is racist. It is a justice system that struggles with oppression and recognizing that, and that communities are over-criminalized. And this will, of course, happen with coercive control as it does with every other crime.
And I would ask if you can answer, what is the effect on survivors when their offenders are released on bail the same day they are arrested?
It's very difficult, and it's been a long-standing reality for a great deal of time. One of the hardest things is not knowing that fact. Sometimes women are not told that they have been released, which is extraordinary to me, as there's so much opportunity to communicate that. Also, as I mentioned earlier, there are so few women that we walk with, and we walk with over 2,500 women each and every year who go to the criminal justice system. In the case of criminal harassment, there have been 5 women I've personally known in my work in the last 20 years who have ever had a charge of criminal harassment. And being held for bail is very difficult to do, and it is necessary for a moment of safety for women to have even a 24-hour period of a break to know and have options available to her to consider.
My another question to you, there was a femicide in broad daylight in Brampton last October involving a perpetrator who was already prohibited from having a firearm. He was out on bail for a firearms offense involving the same victim. What action needs to be taken to address the problem of illegal firearms in intimate partner violence?
Very, very quickly, Ms. Brown.
That is a question I cannot answer very, very quickly. I'd be happy to forward my thoughts on that to the committee.
Thank you very much. Mr. Housefather, 4 minutes.
Merci beaucoup, Monsieur le Président, et Madame Boucher.
Thank you, Chair. And Madame Boucher, I'd like to say, once again, we really appreciate hearing from your lived experience. We really, really appreciate this.
I shouldn't have to ask, and I'm sure you're going to have a very succinct answer like you have been able to do for every other question you've been asked, which I think is fantastic. I had a colleague that claimed that Bill C-16 in the new offenses of coercive control essentially could criminalize everyday interactions in your home with your family. She basically went on to say it criminalizes a pattern of otherwise lawful and often common behavior that may later be perceived as threatening by an intimate partner. That means ordinary family interactions could be reinterpreted as criminal after the fact. Could you let us know what you think about that claim, which I kind of think is outlandish, but I'm happy to hear from you?
Coercive control is about intimidation, constant belittling, dehumanizing behaviors such as controlling what we eat, when we go to the bathroom, whether we sleep, threatening to harm us, threatening to harm the people we love, and threatening to harm the animals that we love. That's not
So, for example,
frivolous.
the example she gave was asking a partner not to give children junk food. You would say that that is likely not something that would fall under this this new article.
I'm a little reluctant, as we've referenced a particular person in the question, so I'm a little reluctant about that piece. I don't know. I don't believe that coercive control will be frivolous. It is anything but frivolous, and it is not about whether the child eats junk food or not. Do I believe that potentially a person who causes harm will bring that up as a controlling behavior that his ex-partner is doing with his child? Yes.
Thank you very much. I want to go to Mr. Khan now, who, because you're not in the room, you sometimes get a little bit left out. But I wanted to ask you about Australia. As far as I understand, coercive control in Australia, criminal law is done by the states in Australia, not by the national government. And Queensland is the one I think you probably referenced that has a more inclusive coercive control definition, because New South Wales doesn't, and I can't find any other states in Australia at this point that do. Should we be looking at the Queensland model? Do you have, and I mean, you mentioned England and Wales, do you have other countries that you want us to look at?
Yeah, Ireland as well. And also, so there's Ireland, there's Scotland, there's England, Wales, there's Australia, Queensland, and New South Wales. So they've all sort of like taken an approach to intimate partner violence in their own way. But three of them, specifically England and Wales, which expanded it a couple of years ago from having intimate partners that were domiciled together to realize that actually the violence can occur from people who are not, in fact, living with you, which is kind of sort of indicative of the fact of coercive control can be prevalent in sort of scenarios that are not sort of perceived by just intimate partners. That approach was
50 seconds. Okay, sorry, please finish if you have any.
I'll be quick. All right, so Ireland is considered it. It was narrow there, and the commission has recommended an expansion to include relatives and caregivers. As you noticed, Queens started off ab initio with an expansive approach, all because of stats, essentially. I just want to clarify that point. It was based on data that we have in Canada as well that sort of allowed them to do this.
Merci beaucoup tout le monde. Fin de la réunion.
Thank you very much. End of the meeting.